Good afternoon. Welcome to the resumed hearing in the appeal of Evergreen Marine and Nautical Challenge. We are hearing the submissions of Ms. Salvaratnam on behalf of the respondent. Ms. Salvaratnam.
I'm still on mute. Thank you very much. May it please the court. I'm conscious that I have 1 hour, 15 minutes. I'm going to allow the court to treat my expose on the authorities as to be taken from my written case. And I'm only going to focus upon the key cases in the course of my argument this afternoon. Mr. Justice Tear's analysis of the authorities is, in our respectful submission, exemplary. Paragraphs 39 to 64 of his judgment, pages 200 to 205 of the bundle, contain his analysis. The Court of Appeal paid tribute to that masterly analysis and offered their own supporting analysis at paragraph 65 to 75 of their judgment. We respectfully adopt in full their analysis of the authorities pertinent to question 1 and for the reasons set out in our written case at paragraphs 24 to 111. My learned friend has sought to categorise in his written case 3 situations and to put our encounter within situation 3. It is hard not to conclude that situation 3 has been deliberately crafted for forensic purposes, as it has no intrinsic nautical appeal. The findings of fact that were made by the court, which we have summarised in paragraph 34 of our written case, to which should be added paragraph 111 of Mr. Justice Tear's judgment as to the knowledge of the Eversmart as to our intended actions as entering the channel, make this clearly a situation 2 case and not materially distinguishable from Culler Mason and Canberra Star, which are themselves situation 2 cases. Eversmart believed that Alexandra 1 was lining up for an orthodox port-to-port passing and would have done nothing different. We refer to what Mr. Justice Tear says in paragraph 81 of his judgment. Now, the scheme that's been proposed by my learned friend Mr. Rainey in the course of his oral address yesterday is equally unsatisfactory in our respectful submission, particularly in his alleged differentiation between the extension principle, his principle 3, and his principle 4. Which seeks to exclude all other cases apart from those where a vessel is already shaping or on her inbound entry approach from that extension principle espoused by Culler Mason. Again, we say that that's been developed for forensic purposes and has no intrinsic nautical appeal. As my lords have observed in the course of interchange with Mr. Rainey yesterday, it is going to be very difficult for a mariner to discern how the other vessel is transitioning from a stage 4 into a stage 3, and a much more realistic and pragmatic and workable test will be the one that applies principle 3 to vessels which are in the position of Alexandra 1, which are known to be about to embark on an inbound entry approach and still outside the channel, but because of their knowledge of the intended actions of the other vessel and their proximity to the channel mouth, will be covered by that extension principle. Now, the directly relevant authorities which I want to focus upon are Canberra Star and Culler Mason. And in order to ensure that I finish on time, I'm going to start with Culler Mason because it does cover discussion of the Canberra Star in the course of the Masterly Review. So perhaps I could ask the court please to turn to the authorities bundle at page 441, which is the Culler Mason case, and I can show you some of the key paragraphs. just so that you're aware, the first defendant in this case was the master of the Neftegas 67 that I'll call N67, and the second defendant was the pilot of the Yao Hai that I will call YH. There were 8 questions of law that were certified as being of great and general importance. The judgment of Mr. Justice Ribeiro considers the first question, which relates to mens rea of an offence under the Shipping Port Control Ordinance. But the other 7 questions were addressed by our own Lord Clerk, and they are set out in paragraph 142, which we'll come to in a moment. Certain of those questions have direct relevance to this appeal. In particular, question 3, does Rule 9 of the collision regulations apply to a vessel approaching but navigating outside a narrow channel with the intention of entering it? That's the formulation that appears on page 486 of the bundle. Question 5, does a vessel navigating within a channel have a right of way over another vessel which is approaching from outside the channel with the intention of entering it? That's dealt with on page 486 and is discussed at paragraph 210 of the decision. And then question 7, do the crossing rules apply when a vessel is approaching a channel on a crossing course involving a risk of collision with another vessel navigating in the channel? Now, Mr. Justice Ribeiro, at paragraph 71, identifies that the unlawful act that was relied upon by the prosecution was a breach of one of the collision regulations, and in particular Rule 9. At paragraph 126, if we could go to that paragraph, please, which is on page 481, the master of the Neftegas 67 had sought to justify his actions leading up to the collision along the following lines. He believed the Boyd Channel was not a narrow channel. Little b is important for our purposes. He believed that the crossing rules, and in particular Rule 15, applied with the YH as the give-way vessel, and therefore that he was bound by Rule 17a little 1 to keep his course and speed. If we then go to paragraph 130 little b, which is on page 482, the judge who tried this matter at first instance concluded at little b that it was wholly unreasonable and erroneous for the first appellant to believe that the crossing rules applied, or that he was bound to stand on and hold course and speed, hogging the channel, and more absurd that he believed that the YH was going to cross ahead of the N67's bow. If we go then to paragraph 131, page 483, the judge found that the master of the N67's belief that his conduct did not endanger, because he was properly following the crossing rules designed to prevent collision, was negated. Any such belief was not held on reasonable grounds. And he found that the pilot of the YH correctly understood that the crossing rules were not applicable, whereas the N67 was hogging the channel and ought to have moved over to the starboard side. We then go to Lord Clerk at paragraph 141, and 142 he deals with the certified questions, and I've identified questions 3, 5, 7 as being material. At 145, dealing with the primary facts, he shows that they were advised by experts, and he says that they were shown a video, like the courts below, of the VTS radar images. Then if we go to the top of the next page, 488, he says that the N67 was proceeding at about 10 to 10.5 knots, dot, dot, like the courts below, we saw a video. And then he says, I will return below as far as necessary to the navigation of each vessel after considering the principal navigational issue between the parties in this appeal, which is whether the N67 was navigating in a narrow channel within the meaning of Rule 9. And ultimately, it's concluded that Rule 9 did apply to the relevant channel. If one then goes to paragraph 150, we see there the arguments of the N67's master that the crossing rule applied. It was said on behalf of the first appellant that the CP channel wasn't a narrow channel and that the N67 wasn't under an obligation to alter course. We then see it was thus submitted that the N67 wasn't to blame for failing to alter course to starboard to proceed close to her starboard side. The judge rejected this submission and held that the principal cause of the collision and therefore loss of life was the failure of the second defendant as master of the N67 to alter course to starboard at an early stage. She held in colloquial terms that he was hogging the centre of the channel. Court of Appeal reached the same conclusion. It was submitted that both courts were wrong to reach these conclusions. I'll return below so far as necessary to the detail of the coal regs and to other aspects of the navigation of the two vessels. But so far as the navigation is concerned, it seems to me that the most important issue in the appeal is whether the judge was correct to hold that the Boyd Channel was a narrow channel, which in fact they duly do conclude it was. Then if we go to 167, this is paragraph number 167, on page 494, the court considers the object and underlying rationale of Rule 9. And the following appears: passing of vessels within this stretch of water. Vessels passing in the channel should pass port to port, with each vessel proceeding as close to her starboard side as safe and practicable. Under Rule 9, the vessel in the channel should plainly do so, because vessels entering the channel will expect her to do so. Vessels navigating in the Boyd Channel, seeing vessels approaching the Boyd Channel from Marwan Island in the opposite direction at an early stage, are likely to see a number of alterations of course of these vessels, as they may be constantly changing their aspect in order to shape a course into the channel. Safety requires a vessel approaching the channel so as to proceed along it to navigate so that if the vessels pass in the channel, they will pass port to port. This will be achieved if the narrow channel rule applies. If it does not, there is considerable scope for confusion. We clearly do rely upon that statement of principle, which supports the formulation of the principle adopted by the lower courts in this case. If we then move to paragraph 181 on page 498, we can see a reference in the last 5 lines as the plot in Annex 2 shows. The position throughout, assuming of course that they were looking, was that the N67 could see the green starboard light of the YH and the YH could see the red port light of the N67. They were crossing vessels, not end-on vessels. No competent mariner could have thought otherwise. If we then go on to the discussion, paragraph 182 confirms that the judge was correct to hold it was a narrow channel. And then if we go to paragraph 194, which is on page 502, the judge says this: I see the force of the general points made by Professor Allen, but I don't see how this court can, for the first time, lay down principles of navigation different from those which have been accepted to date. It must approach them as mariners would do. For these reasons, I would reject the submission that in the absence of a published designation or declaration that a channel is a narrow channel, the channel should either be conclusively treated as not being narrow, or that there should be a strong presumption to that effect. We then go on to consider at paragraph 200 and following the duties of the N67 and her master. And at paragraph 201, well, let me read 200. It isn't in dispute that the vessels were aware of each other from about at 2108 at the latest, it follows from the conclusion that the N67 was navigating in a narrow channel that it was her duty and that of her master who was navigating her to keep as close to the starboard side of the channel as was safe and practicable. It was thus his duty, if he wished to remain in the channel, to alter course to starboard at about 2109 to navigate close to the line between the Siu Mo Tow northeasterly mark and buoy CP2. That was his duty regardless of the position of the outbound vessels YH and Berlioz. He was not bound by the crossing rule but by the narrow channel rule. And then the judge quoted the following passage from the Empire Brent, which we have seen before, but let me just remind you of the last 5 lines of the extract. There is no room in such a situation for applying the provisions of the crossing rule at the same time as the provisions of the narrow channel rule, because the requirements under the rules are different. I have no hesitation in saying that as between a vessel approaching each other in that way in a narrow channel like the Mersey, the narrow channel rule and the narrow channel rule only is the rule that has to be applied. Nor do I think it was suggested that the crossing rules applied to the N67 if she was navigating in a narrow channel. In any event, the principles stated by Mr. Justice Woolner are plainly correct. If we then go to 203, the last 5 lines, the principal cause of the collision was the failure of the N67 to alter course to starboard at about 2109 or soon thereafter in order to make it clear that she expected to pass port to port at a safe distance when she was close to the southern side of the channel. The judge held that she should have altered the course about 12 degrees to starboard. Then at 204, skipping down 4 lines, if the N67 had altered to starboard to proceed on her starboard side of the channel, there can be no doubt that the vessels would have passed safely port to port within the channel in the vicinity of buoys CP1 and CP2. Then over the page, the judge held that the first appellant, that's the N67, ought to have appreciated that the YH and the Berlioz were shaping to enter the channel. And then if we scroll down to 206, as can be seen on the plotted Annex 2, as they approached each other, the N67 could see the green light of the YH and the YH could see the red light of the N67. As shown on Annexes 2 and 3 and the charts, N67 was on a steady course of between 090 and 092 to port of mid-channel from 2109 until 2112.50 when she went to port. The helm orders were then set out. If you then go to paragraph 208, Lord Clark says this: in order to determine the appeal of the first appellant, it isn't necessary to determine any of the other certified issues of law, because apart from issue 3, which was the question about whether Rule 9 applies to a vessel approaching but navigating outside a narrow channel with the intention of entering it, which affects the navigation of the YH, and to which I will return. The other issues, with the possible exception of issue 5, that is, which vessel has right of way, and 6, the Rule 8 point, which we don't need to consider, are relevant only if the channel is not a narrow one. If we then go to paragraph 210, he confirms that issues 5 and 6 don't arise, and that there is no arguable possibility that the N67 had a right of way over vessels entering the channel. And that's quite important when looking at how one categorises the situation in the present case. If one then goes to paragraphs 217 and 218 of the judgment, starting at page 509, the judge says this, having analysing the decision of the judge below. Having referred to the Empire Brent, which on its face applies to vessels in the channel, the judge said that, basing herself on the evidence of Captain Simpson, just pausing there, he is a well-recognised nautical expert, master mariner, that vessels approaching the channel and vessels within it must acknowledge that there must be some continuity, so that Rule 9 applied at the entrance to the channel in order to avoid chaos and ambiguity. She referred to the decision of Mr. Justice Hewson in the Canberra Star, where he said that if a vessel is entering the channel to proceed along it, in circumstances where there is another vessel already in the channel, the crossing rule does not apply. He said this at 28 where a vessel proceeding downriver outside the channel, intending to enter it, sees an upcoming vessel B approaching her in the next reach, bearing on her starboard side on a made channel course, which, if followed into the reach in which A is navigating, will or should enable the two vessels to pass safely port to port by reason of the fact that B should keep to her starboard side of the channel, the crossing rule does not, in my view, apply. It does not appear to me that the vessel already in the channel has a complete right of way, and she must not hog the channel, regardless of the reasonable aspirations of the other ship. You'll note there the key paragraph in the Canberra Star, which is what I would have referred to had I taken you to the case itself, was the fact of proceeding downriver outside the channel, intending to enter it. That is what triggers the extension principle and makes this a situation 2 case, using the designation in my learned friend's written case, not a situation 3 case. And Lord Clark says in 218, that makes good sense to me. And then he continues, the judge held that N67 shouldn't have assumed that the YH would leave the channel, but should have expected them to enter the channel on their starboard side, close to the buoy CP1. She should therefore have altered to starboard onto her own starboard side to facilitate that manoeuvre. And then the judge gave her reasons for criticising the N67 for hogging the centre of the channel. If one then goes to 2.1, on page 512, Lord Clark says that between certain paragraphs, the judge considered whether it was unreasonable for the first appellant to believe that the crossing rule applied, and held that it was not. As I see it, if it was unreasonable for him to believe that the narrow channel rule didn't apply, it was unreasonable of him to think that the crossing rule applied to the N67. As already stated, the narrow channel rule applies to all ships, and where the rule applies, there can be no reasonable basis for concluding that the stand-on rule applies. We place emphasis on that. And then at 224, last 3 lines, I'm satisfied for the reasons given by the judge that the prosecution has established beyond reasonable doubt that the first appellant had no reasonable grounds for his belief that the CP channel was not a narrow channel and that the crossing rule applied. And he therefore concludes there were no reasonable grounds for believing that he was navigating safely and without danger. If one then goes to paragraph 225, one considers the duties of the YH and her pilot, the second appellant. At 225, the judge says this: I've already concluded that the CP channel is a narrow channel. I've also expressed the view in 217 above that vessels approaching a narrow channel and intending to proceed along it, again note the formulation which accords with the principle as we say it should be formulated, are not bound by the crossing rule but must enter the channel, and as they do so, keep as near to the starboard side as is safe and practicable in accordance with Rule 9. It seems to me to follow that a vessel shaping to enter the channel should, as a matter of good seamanship, navigate in such a manner that when she reaches the channel, she is on the starboard side of the channel in accordance with Rule 9. And just pausing there, you will note that that accords exactly with the seamanship advice that was given to Mr. Justice Tier in this case, and which has led to the formulation of the principle which disapplies the crossing rule. Continuing to read 225, the judge in effect so held and was correct to do so. This approach is consistent with that espoused by the Court of Appeal in England in the Kaiser Wilhelm de Gross, where Chief Justice Lord Alveston said the duty of the O was undoubtedly to get well over, as far as she could safely get, to the western side of the entrance so as to enter fairly close to the side of the channel, which is Fort Chavagnac. And then he answers question 3. As I read the report, the reference to the entrance was a reference to the entrance to a narrow channel. I would so answer the question raised by issue 3 if it were necessary to do so. Now, 226 deals with the actual navigation of the YH, and it's in that context that the court says that YH was in fact navigated in such a way as to shape to enter the channel in a correct position on her starboard side of the channel near buoy CP1. Now, that does not form part of the formulation of the principle. The principle is set out in 225. 226 is merely the factual confirmation that she complied with the relevant principle that applied to her navigation. In our case, the principle is the same as that set out in 225, but the actual navigation of the Alexandra one did not comply with that principle, which is why we have been criticised and found to blame 20% for this collision. Now, the Cullum-Mason case is clearly a situation 2 case, which my learned friend accepts in his categorisation, results in a disapplication of the crossing rule. The position that he has adopted in oral argument has made a concession that was certainly not apparent from the written case, and certainly not apparent from the way the matter was argued below. From the written case, it appeared that Cullum-Mason was said to be marginalised because it was concerned with a criminal conviction, and below it was said that Cullum-Mason was therefore of no assistance to the court. It's now recognised that Cullum-Mason does have a role to play, and it is said to be an illustration of the extension principle, whereby it is Rule 9 that governs where you have a vessel that is approaching the channel intending to enter it in the Cullum-Mason sense and the Canberra Star sense. We say that based upon the findings of fact that the judge has made, we are clearly to be treated as falling within the same category as the principle in Cullum-Mason. And we respectfully refer to the findings that we've set out in terms of the understanding that Eversmart had about what the Alexandra one was shaping to do. They're set out in paragraph 34, to which one must also add Mr. Justice Tear's observations in paragraph 111 of his judgment that I've taken you to a number of times, page 219 of the report, where he finds it was known that Alexandra one was outside the channel, preparing to enter it, and that the vessels might meet either in the channel or in the approaches to it beyond the number 1 buoys. We say that those primary findings of fact make this case not materially distinguishable from Cullum-Mason, and that the principle should be as formulated by Mr. Justice Tear and the Court of Appeal in relation to the rules that governed the encounter between the Alexandra one and the Eversmart. My learned friend in oral argument yesterday made a list of 6 propositions which go beyond what need to be resolved in order to determine the rules applying to the encounter between our 2 ships. However, the categorisation of his point 3, the extension principle, and the differentiation between that and his principle for all other cases, the crossing rule will apply, begs the question of how you tell when a case falls within one or the other. Again, it appears that category 4 has been developed forensically in order to try to exclude the Alexandra one from its ambit. When you look at what was known and understood by the Eversmart and the findings of fact in that regard that have been made by the court, there can be no doubt that the appropriate categorisation is his principle 3, where one vessel is proceeding in the narrow channel to the channel exit and another is on her inbound entry approach, but still outside the channel, the crossing rules would not apply. And we would qualify the reference to inbound entry approach by reference to the fact that in Cullum-Mason itself, it was only said that the vessel intended to proceed along it. And here we have the factual matrix as found by the court that it was known that she was intending to proceed along it and that there was no other reasonable inference to be drawn from the Alexandra one's position, but that she was on the verge of proceeding to enter the channel. The fact that she may not have lined up precisely, oh, I'm sorry, Lord Burrows, yes. Oh, I'm sorry, you're on mute.
Sorry, thank you very much. So as I understand it, you are here accepting the submission of Mr. Rainey that his proposition 3 is correct That is that where you are shaping, where the inward bound vessel is shaping to enter the channel, the crossing rules do not apply. But you are then saying that in our case, there's a factual finding in your favour that Mr. Rainey would dispute that the Alexandra was, you say, was shaping up. He would say was not shaping up. But as the way you've just presented it, seems to me the principle doesn't appear to be in dispute between you and Mr. Rainey. Is that correct?
Let me clarify. His extension principle 3 does not state the principle as widely as it needs to be stated. His principle 3 certainly does cover the Culler-Mason situation, but he's put a gloss on it. He's implied that it's necessary for the vessel in the position of Alexandra 1 to have commenced her inbound entry approach. We don't say that that is a necessary ingredient. All that Culler-Mason requires is that you have vessels approaching a narrow channel intending to proceed along that narrow channel. And given the factual findings that have been made by the judge in our case, endorsed by the Court of Appeal, we are to be treated as falling within the extension principle when correctly stated, because his principle 4 has been developed for forensic purposes, and his constraining expression of the extension principle has again been created for forensic purposes to try and exclude Alexandra 1.
My understanding is that, at least in oral argument, his proposition 3 was essentially shaping to enter the channel. Now, you have come back, as I understand it, to say, well, the important principle is whether you are intending to enter the channel. But that isn't the submission that Mr. Rainey's putting forward. Clearly, if you're intending to enter the channel, that can include a ship that's hovering around, going in completely a different direction, but is actually in the waiting area, intending to enter the channel. But they're not shaping to enter at that point, are they?
Lord Burrows, I'm not accepting against myself that his statement of the extension principle is correct. All I am saying is that he has recognised that the crossing rule will not apply in a case where a vessel is actually shaping on her correct down channel course. My case is that when you look at the authorities and what lies behind the formulation of the principle in Culler-Mason, which does not depend upon formulating the duty by reference to the need to be in a shaping position, he has unfairly and incorrectly confined the scope of the extension principle in a forensic manner to try and exclude Alexandra 1 from its ambit. When you look at paragraph 225 of Culler-Mason, what is said there is that vessels approaching a narrow channel and intending to proceed along it are not bound by the crossing rule, but must enter the channel, and as they do so, keep as near to the starboard side as is safe and practicable in accordance with Rule 9. And he'd said much the same in his earlier paragraph 217, which had cited from Canberra Star, where the principle was stated thus: where a vessel proceeding downriver outside the channel intending to enter it sees an upcoming vessel be approaching her in the next reach, bearing on her starboard side on a main channel course, which, if followed, would lead to the two vessels passing safely port to port. By reason of the fact that B keeps to her starboard side, the crossing rule does not apply. We say that the extension principle is not to be confined to cases where the putative give-way ship, in our case the Alexandra 1, is in fact actually shaping to join the channel. The principle bites where objectively everybody knows that the putative give-way vessel is in the pilot boarding area, approaching the channel, intending to enter it once the pilot has gone on board. And it is that very situation which was spoken of in the Peking by the Privy Council, to show that vessels in that position would not be crossing vessels because everybody knew that their courses would not bring them into conflict.
Can I test this by a slightly different example? Suppose that a vessel is approaching a narrow channel, let's say the entrance to a busy harbour, and intending to enter it as soon as she can, and has been told by the harbour authority to wait until she's given clearance to enter. So she bumbles around outside the entrance, waiting to enter. Now, in those circumstances, if a ship is coming out of the narrow channel, in a situation where if they collide, it'll happen outside the entrance, do the crossing rules apply?
I would respectfully say that it depends upon, objectively, what is understood by the vessel coming out of the channel. If the
suppose that the vessel coming out has heard the exchange with the port authority and knows that the vessel is intending to come in, but has to wait for an event to happen. In that case, permission from the port authority. In our case, it's taking on board his pilot, but I'm just using a different example to try and focus the point of principle.
If the vessel that is about to embark on navigation into the channel is in the vicinity of the channel entrance, such that the vessels can be expected to pass each other in that vicinity, then we would say that the crossing rule does not apply.
Really? Okay.
Could you help me on this, Ms. Selvaratnam? Going back to the facts of Kunanesin, the incoming vessel, the Yar High, am I right in thinking that that had actually commenced its inbound entry approach?
She was, in fact, on the facts, as we see from 226, being navigated already in a way so as to shape to enter the channel. And we looked, I think, at Mr. Rainey's Annex 3, which is attached to his case, to show that she was further along the process of actually navigating to enter the channel. But we say that that question of whether she was complying with her duty being to approach the narrow channel in such a way as to do so on her own starboard side when she reached the channel, was not breached by the Yar High in that case because she complied with the duty. But the duty is the same duty in our case.
I understand the important difference between duty and breach. But the reason I ask is that you criticise Mr. Rainey's Principle 3. You say it's not wide enough because it implies that the vessel must have commenced an inbound entry approach. And it seems to me that Kunanesin is a case where the vessel had commenced an inbound entry.
That is correct, my lord. I do accept that. But we say that given the factual findings made by the judge here, which we have summarised in paragraph 34 of our case, as supplemented by paragraph 111 of Mr. Justice Tear's judgment, the Eversmart clearly believed that Alexandra I was lining up for a conventional port-to-port passing and would have done nothing different. So as far as she was concerned, we were in the same position as the Yao Hai was in relation to the Neftegas 67.
But that depends on the subjective understanding of the master of the Eversmart.
It does, and we have factual findings about that. We have the finding in paragraph 111 of Mr. Justice Tear's judgment that it was known to the Eversmart that the Alexandra I was outside the channel preparing to enter it, and that the vessels might meet either in the channel or in the approaches to it beyond the number 1 buoys. And we would remind you also of what we've said in paragraph 64 of our case, where we say that Eversmart believed Alexandra I was lining up for an orthodox port-to-port passing because of the discussion the judge has at paragraph 81, and would not have done anything differently if the Alexandra I had complied with her obligations under Rule 2 or the crossing rules, whichever had applied.
Thank you.
The point that I'm seeking to make is, as we say in paragraph 62 of our case, that the way that the appellant now puts its case is that it's clear now that the difference between what Alexandra I actually did and what Eversmart says she ought to have done if the crossing rules had applied was equivalent to the very same breach of duty that counted against the Alexandra one when the judge apportioned her 20% of liability for the collision. And we say it would be double counting to treat a failure to give way in accordance with the crossing rules as an additional fault, and breach of the crossing rules will not without more amount to negligence. So at the end of the day, even if you were to conclude that the crossing rules governed the encounter, exactly the same conduct would have led to our vessel shaping to have entered the channel at C-4, C-5 by turning to starboard. That is what we've been criticised for because of the breach of Rule 2, not lining up appropriately to enter the channel when we reached it as far on the starboard side as possible. We've been penalised 20% for that. So at the end of the day, it should not make a difference. But setting out a principle whereby the crossing rule will apply to this encounter will cause inconsistency in approach between ourselves and Hong Kong, will lead to confusion and will not lead to improvement of safety standards. It is not irrelevant that the decision of the court in the Alexandra One case has been met with approval, both in Hurst's textbook, which you have, and also in an article in the Lloyd's Maritime Law Quarterly, written by Mr. Morley, who I believe is a practitioner at 7KBW, with contribution from members of Trinity House. I would commend those particular works to you. They are in volume 4 of the Authorities Bundle.
Lord Hamblin?
Yes, is there any relevance on your case at the judge's finding at paragraph 70 that he would describe the Alexandra One as waiting for the pilot vessel to arrive rather than being on a course? Is that finding relevant to this argument we're considering?
Well, it certainly makes the intention of the Alexandra One very plain, and it shows that she's in the vicinity where previous authority, like Culla Mason and Canberra Star, have a regime of Rule 2 / Rule 9 applying, not the crossing rule regime applying. We submit that a very workable principle is as set out by Mr. Justice Tier, informed by the seamanship advice that he received, and that principle was not departed from by the Court of Appeal. We would invite the court to be very wary of overgeneralising the decision to include reference to dissimilar cases. The Court of Appeal very prudently confined itself to cases that were identical or very closely allied on the facts. Now, my learned friends below, and again on the appeal, have sought to stress test the conclusions that were reached on the actual encounter between the Alexandra One and the Eversmart, which involved a west-east encounter, by reference to what ought to happen on an east-west encounter. Now, I don't particularly mind what decision you make about an east-west encounter, because it doesn't impact upon the view that you form of a west-east encounter. But it is noteworthy that the seamanship advice that was given to the Court of Appeal on this east-west encounter was again consistent with the narrow channel rule being the rule that applied and not the crossing rule. If I could ask you to look at the Court of Appeal judgment at paragraph 84. That's going to be in your bundle at page 171. Well, in fact, let me take you earlier. The question that was posed is at 79 on page 169. In the event, the question posed to the elder brethren was in these terms: in circumstances where a vessel is proceeding outbound in the dredged channel. An incoming vessel is approaching the mouth of the channel from the east on a broadly westerly heading. A risk of collision between the two vessels exists in the vicinity of the entrance to the channel. What actions would you expect from a prudent mariner in accordance with the ordinary practice of seamen? And we see that the elder brethren give the following answer, which is not consistent with the crossing rule applying. They say a prudent mariner in the outbound ship would keep a sharp lookout, ensure compliance with Rule 9 by staying on the starboard side and proceeding at a safe speed, acquire the vessel coming from the east as an ARPA target at an early stage and watch its bearing to determine risk of collision, consult the onboard pilot and port control about the vessel's identity and intentions, make contact with the other vessel by VHF at an early stage to advise of one's own ship's constraints in the narrow channel and intentions when dropping the pilot, and be prepared to adjust own ship speed to resolve close quarter collision risk if necessary, with the constraints of remaining in the channel and on the starboard side. He would then proceed to a safe speed, at a safe speed in the vicinity of the fairway buoy before increasing to full sea speed. So again, avoiding the pilot boarding area and all the difficulties that poses. The prudent mariner in an incoming vessel approaching from the east would keep a sharp lookout, consider approaching via the fairway buoy to avoid a close quarter or collision risk in the vicinity of the channel, particularly if not immediately entering the channel, acquire information from port control regarding pilot boarding time, and ensuring that when manoeuvring to pick up the pilot, he stays clear of the channel mouth and lines up to enter on his starboard side, acquire the outbound ship as an ARPA target at an early stage and keep a close watch on it, identify and make early contact with the outbound ship on VHF in order to ensure the collision risk is avoided, and agree to keep clear of the vessel navigating under pilotage in a narrow channel. This accords with the ordinary practice of seamen having regard to the particular circumstances of the case. Now, Mr. Jacobs, appearing for the Eversmart, as we see in 81, launched a vigorous critique of that answer. It was unclear whether the elder brethren considered that the hypothetical encounter was governed by the crossing rules unless they applied. The answer in that hypothetical situation lacked clarity, so he said, and certainty, as did the judgment. There was no rule of priority, it was more a workaround than a solution. It relied on VHF, which was fraught, as he said, with potential difficulty and had been criticised by courts in the past. Further, he said the reasoning of the elder brethren had completely undermined the judge's approach to the faults of the Alexandra one, so requiring the judge's apportionment to be revisited. Ms. Salvaratnam's response was that the answer was entirely consistent with the advice given by the elder brethren below to Mr. Justice Tier, because both sets of answers show that the crossing rule has no role to play in the approaches to a narrow channel, and we stick by that observation. The suggestion that Eversmart interest should be given permission to appeal on the question of apportionment in the light of the answer was extraordinary and deeply flawed. He deprecates in 83 the attempt to reopen apportionment, but then at 84, turning to the substance of the answer, I accept the advice of the elder brethren and am unable to accept the criticisms advanced by Mr. Jacobs. The elder brethren were, of course, concerned with seamanship, not law, but it's plain from the answer that they didn't consider the crossing rules to have any role to play in the hypothetical east-west situation. To my mind, the answer provides a comprehensive, realistic guide to safe navigation for both vessels, according to the requirements of good seamanship and governed by Rules 2 and 9. The attraction of the rule of priority under the crossing rules is understandable, but less than compelling in the situation with which we are concerned. In my judgment, the answer reflects the practical reality of good seamanship within this port area, and we would endorse that, my lords. I would not certainly in any purgative sense describe it as a workaround, nor do I read the answer as placing any inappropriate reliance on VHF communications. On the contrary, the answer rightly includes VHF communications as amongst the means the prudent mariner would employ to assess and reduce the risk of collision. In any event, the application of the crossing rule would itself not be free from difficulty in the hypothetical east-west situation. Thus, the putative give-way vessel would be navigating in the narrow channel and constrained by it. So too, the putative stand-on ship would be required to keep her course and speed as she manoeuvred through the pilot boarding area. In short, the attractions of the crossing rules in this situation may be more forensic than nautical. And he concludes, for all those reasons, I'm amply satisfied that a consideration of the hypothetical east-west situation does not undermine the judge's solution to the actual west-east encounter. On the contrary, the advice is entirely consistent with the approach adopted by the judge, and we would commend that to the court. And of course, the court is going to be assisted by its own nautical assessors. And although it is not generally thought to be advisable to ask the same questions of one's own assessors, where those questions have already been asked and answered below, and especially where there's been no appeal in relation to those seamanship questions, the court may consider formulating different questions that may shed light on the prudence of disapplying the crossing rule in that situation also. So, can I then ask you to, by way of summary, to allow our formulation of the principle that should govern the approach of the vessels in this case to govern, which will entail the dismissal of the appeal in relation to question 1. As I mentioned, the way in which this case has been decided by the lower courts has been commented upon favourably both by Mr. Hurst, a partner within Ince & Co, who has written a book on collisions at sea, where the relevant extracts are appended in your volume 4 of the authorities, and the result in the case in our decision at first instance in the Court of Appeal has been also commented upon favourably by Mr. Morley in his Lloyd's Maritime Law Quarterly article, also in volume 4. Now, my learned friend has said a lot about the Ashton, which appears to have been an ex-tempore decision based upon the way in which it's treated in the Morley article. And the Ashton is also treated in the Morley article as being anomalous. And we would say that it really has very little weight at all. If we go to the Ashton, it is in your first main volume of authorities at tab 3 at page 330. My learned friend's already taken you to the facts in detail, but you must look at the tentative and impressionistic way in which this apparently extempore decision was reasoned. If we go to page 336, just at the end of that first main paragraph, my impression, he says, my impression is that the narrow channel rule does apply to the place where this collision happened, and that the vessel which come out properly should round the clean S buoy, and the vessels going in should keep well away from the clean S buoy, so as to allow the outward traffic to pass between them and the clean S buoy. And then he says, I don't think it makes any practical difference whether the strict terms of the narrow channel rule are treated as applying or not, because it's quite obvious that any vessel coming out from Grimsby must come as the defendant's vessel came, practically down on the line of the sector from the Spurn Light and quite close round the clean S buoy, and that if any vessels coming up must make an allowance for that position. That is to say, the incoming ship would have to allow the downcoming vessel room to pass there. And so, to my mind, it doesn't make much difference whether you do or you don't treat the rule as strictly applying. So it was certainly not subject to the critical analysis that this issue of the conflict between crossing rule and narrow channel rule has been subjected to in each of the 3 levels of court in this case. If you go on to the next page, page 337, middle of the page, he says, the next matter to consider is whether the crossing rule came into force in this locality. The impression, again, rather sort of woolly, which I have formed is that it does. The traffic going up and down the river has to go past in this locality, the traffic coming out of Grimsby, which has, speaking in general terms, to go across it to get into position. And therefore, vessels at certain times and places seem to me necessarily to be in the position of crossing vessels. Again, there has been no serious argument of the kind canvassed in the present case as to whether this in fact is a case that attracts the crossing rule. It's all in very general terms. And if we go on to the next page, page 338, we see that the judge is keen to stress that whatever view is taken of the rules, it doesn't make any difference. You can pick that up at the end of the very long paragraph, 2/3 of the way down below the hole punch. Whatever view is taken of the rules, I think the plaintiff's vessel must be held to blame. So the Ashton is not the get out of jail free card that Milo and friends hope it might be. And we would ask you to look at the critique of that case in the Morley article, because it is thought to be out of line in any event, even if it was authority, which we respectively submit it's not. We've made a reference to the Morley. The reference in Morley is to footnote 67 for your reference. Yes, Lord Burrows. I think Lord Burrows wants to ask me something.
Yes, you're muted, Lord Burrows.
Yes, sorry. My understanding of the Morley article was that the main proposition being put forward was that the Court of Appeal had got this decision correct, but for entirely the wrong reasons.
No, if you go to the conclusions, the decision, the actual decision in relation to the encounter, the West-East encounter that we in fact are dealing with is correct. What the Morley article suggests is that an opportunity has been lost to formulate a more generalised principle applying to other cases. And my submission is that that's neither here nor there. The court should be concerned with the facts that are laid before it. And the Court of Appeal was rightly wary about trying to legislate for future cases, which may have very dissimilar and not necessarily foreseeable facts when one's trying to hypothesise them. So if you look at the conclusion at page 1014.17, this is of tab 45, what he says is, while the Court of Appeal's decision in the Eversmart was a correct application of the Colregs to the facts, so nobody's suggesting they got it wrong on the facts, its discussion of the East-West stress test failed to identify the principles underlying the question of whether the crossing rules apply to a situation in which the narrow channel rule also applies, and in so doing created problems for mariners. The case law shows, consistent with good seamanship, that crossing rules apply provided the crossing situation hasn't been brought about through failure to comply with the narrow channel rule. And just on that point, the written cases have made reference to the counterfactual, which was an agreed counterfactual, which was a plot that was created by both teams of solicitors working together. That agreed counterfactual showed that if the Eversmart had kept to her own starboard side of the channel, there would have been no collision. So the causative impact of the Eversmart's failure to keep to the starboard side of the channel was very significant indeed, because there would have been no collision had she maintained the starboard side of the narrow channel. I'll find the counterfactual for you. I think it's in volume 1 at tab 7.7 tab E at page 256. That's the pagination, which shows Eversmart's track to starboard side of channel where the collision is avoided. As we know,
sorry, could you give me that page number again?
Yes, it's page 256 of core volume 1. I hope that's the right page. I've got two page numbers on mine.
Let me check. Yeah, but I think so. It's headed Eversmart track to starboard side of channel.
Yes, correct.
Yeah.
Correct. And again, this is a further reason why it isn't necessary to lay on an additional layer of complication by requiring the crossing rules to govern, because all that needed to happen was Eversmart to comply with her starboard side obligations, and there would have been no collision. When one looks at the underlying reason for this appeal and the strenuous arguments about the application of the crossing rule, it is all in an attempt to try and minimise the very serious and culpable breach of the narrow channel rule, and to seek to place the preponderance of blame upon a ship, namely the Alexandra I, that was simply waiting for boarding her pilot, intending to enter the channel, and who made an understandable error in overhearing VHF conversation, and because of that did not turn to starboard at C-4. But we know that at C-2, she put her engines astern as part of a collision avoidance action and therefore began to cant to starboard. So she had effectively 2 minutes when she was not doing what the relevant duty that we formulate required her to do. While we have the Morley article open, shall I just show you what is said about the Ashton? It's on page 1014.14. At footnote 67, the following appears. There is one anomalous case, the Ashton. A vessel coming onto Grimsby and a vessel coming into Grimsby collided in the Humber. The inbound vessel was on her wrong side. In an extempore judgment, Mr. Justice Gorrell Barnes held that the crossing rules did apply because traffic going up and down the River Humber has to go past, in this locality, traffic coming out of Grimsby, which has, speaking in general terms, to go across it to get into position. And therefore vessels at certain times and places seem to me necessarily to be in the position of crossing vessels. I would respectfully say...
Yes. My pagination is completely different from yours at this stage. Could you give me the page, the manuscript page number of that you're looking at in the Morley article?
255, my lord.
That's very helpful, and I can just go and find it.
I think it's electronic page 1042.
Ah. I don't quite know what's happened with the numbering.
Yeah, it is.
But it's footnote 67. But what he goes on to suggest, after concluding the sentence, which, and therefore vessels at certain times and places seem to me necessarily to be in the position of crossing vessels, at page 28, the author says, I would respectfully suggest that this was wrong. This was not a case in which either vessel was proceeding to or from a port further up the Humber than Grimsby, and so vessels were not necessarily in the position of crossing vessels. The crossing situation arose, as in the Empire Brent or the Glenfalloch, solely from the inbound vessel getting on her wrong side of the channel. It was a Category 1 case, and you can see his categorisation from further up the page, 255. Category 1 is where a crossing situation with the risk of collision arises from a vessel's failure to observe that primary principle. The crossing rules do not and cannot apply to determine what action vessels should take, Category 1. And then Category 2 is where a crossing situation with the risk of collision would arise even where the primary principle is complied with, and the crossing rules then apply, Category 2. And so he says the crossing situation, as in Empire Brent or Glenfalloch, solely from the inbound vessel getting on her wrong side of the channel, it was a Category 1 case. The crossing rules therefore properly should not have applied. Gorrell Barnes J evidently had some doubt whether they did, because he went on to give reasons as to why liability was apportioned the same way, even if they did not apply. If I may just ask my junior if there are other points that he wishes me to run at this point, my lords, I wonder if you bear with me. I'll just do this. My lords, unless there is anything further that I can assist you with in relation to issue 1, I do just want to make 2 further points on question 2. Now, the appeal is whether one needs to be on a sufficiently defined course as the putative giveaway ship, or whether it was enough for the putative giveaway ship to have a heading, even if it was one that was constantly changing. And we would respectfully suggest that the court mustn't be seduced by the notion that it's sufficient for this appeal that the Alexandra one was on a broad east-south-easterly course. Finding that Rule 15, the crossing rule, applies on that basis would be to find that, in fact, contrary to the judge, the Alexandra one was on a sufficiently defined course. Question 2 is whether a sufficiently defined course is required, not whether we were on one. We were not. See Mr. Justice Tier. And just finally, on inconsistency and approach to construction. Unlike in a commercial contract, where you might strain to construe two provisions so as to be compatible, here, Rule 2 is the overriding point because it promotes safety and everything else must be subjected to that. These rules are a guide to the avoidance of collisions for mariners, and they must be construed with that overriding point in mind, which is why Mr. Justice Tier and the Court of Appeal were so concerned about inconsistency between Rule 9 and Rule 16. I think I'm nearing the end, if I haven't already reached the end of my time allocation. So unless there are any further points that the court would like to put to me, those are my submissions on behalf of the Alexandra one interests.
Lord Briggs has a question.
Yes, it's really just to clear something up. You've repeatedly said that the judge only apportioned 20% of responsibility to Alexandra for the blame. My reading of his judgment thus far suggests that in terms of responsibility for the collision, the parties were equally. But Alexandra only ended up paying 20% because Eversmart bore much the greater responsibility for the damage by going too fast.
It was a combination of culpability and contribution to damage, and that formed part of what the investigation was in the Court of Appeal. And it's certainly true to say that the contribution to the damage was a significant feature that led to the overall apportionment. Yeah. But what gave rise to the overall 20% and the only fault, essentially, of the Alexandra one was her failure to alter course to starboard at C-4, C-5, which was because of her incorrect appreciation of that VHF conversation, which she had overheard. But in terms of the actual damage that was caused and the contribution to the damage, then the Eversmart speed was undoubtedly the primary contributor. And if you have a copy of that supplemental bundle that had the radar stills in it, there is in fact a picture of the damage to the Alexandra one's bow, which you may find useful to look at.
I have looked at it. It's graphic.
My lord, thank you.
Lord Hamden.
Sorry, you referred us to the Morley article. As I understand, you're not arguing in support of the so-called principle.
No, I mean, all I was drawing attention to it for was just to show that the actual result that was reached by Mr. Justice Tier and the Court of Appeal has generally found favour, has been found to be intellectually rigorous and consistent with the particular thesis that the author was putting forward. The only criticism was the failure of the Court of Appeal to formulate a more wide-ranging principle that might have applied to other cases. I don't agree with that criticism. I think the Court of Appeal was very sensible in confining itself to the present facts and very closely analogous facts.
And also, in the light of the discussion there's been, are there any questions that you consider that we should be contemplating asking the assessors in this appeal?
I may need some time to formulate those, but it may be that you could ask the assessors whether it would be good seamanship for the Eversmart to maintain course and speed entering the pilot boarding area.
Right.
How would that, I'm very interested in this question too, how would that particular question help us? Are you able just to summarise it? I know you can't do everything today.
Yes, well, the reason that is a relevant question to ask is because it would inform safety of navigation. And if an application of the crossing rule with its mandate to the stand-on vessel to maintain course and speed would have the result that a literal interpretation of that would cause the stand-on vessel to plough at 12.5 knots into an area where waiting ships are going to lie that are not very manoeuvrable, heavily laden, etc., that may be relevant. And the Court of Appeal certainly thought it was relevant because that is one of the special circumstances of the location of our collision.
Yes, I'm not sure how it goes to the construction of the rules. That's my problem. I can see the apportionment, if we were to be doing that, would be relevant.
I would respectfully submit it does go to the construction of the rules because safety is the touchstone of construction, Rule 2B. So if the consequence of applying the crossing rule would be to lead to unsafe consequences, then you do not apply the crossing rule because safety is paramount.
Yes. Is there anything more that you want to say about the vicinity point? Because there's obviously it's common ground that the continuity principle applies. We're really talking about the difference between the continuity principle and the vicinity.
Yes, it will all depend on the facts and the proximity of the waiting vessel or the vessel that's preparing to enter will obviously inform the objective understanding of the vessel in the channel as to what the intentions are. But if on the evidence it is apparent objectively that the vessel in the channel ought to know, and on our findings of fact does know, that the ship outside the channel is intending to enter and preparing to enter, then the principle that has been adopted by Mr. Justice Tier with the advice of the elder brethren and approved by the Court of Appeal will apply and the crossing rules will not.
Thank you. So if there are no further questions, we'll call on Mr. Ray to reply.
My Lord, what I propose to do is to deal first of all with some. So I muted myself, and then I think I was muted again by the controller, and now I've been unmuted by the controller. So I'll just. I'm unmuting myself now. Please don't.
We can hear you loud and clear.
Thank you very much. What I propose to do is to deal with some overarching submissions which are relevant to both issues 1 and 2. And then I'm going to deal with issue 1, and then I'm going to deal with issue 2 in the order in which I addressed it in my first oral argument. The two overarching points I want to make in relation to both issues 1 and 2 are firstly in relation to the views of the assessors in the courts below, and secondly in relation to the pilotage boarding area point, which is now assumed a much greater importance on the basis of the submissions of the respondents. In relation to the views of the assessors below, reliance has been placed on the views of the assessor before Mr. Justice Tier as having shaped in some way the judge's conclusions on issues 1 and 2 as to what a vessel could and should do. And indeed, I think it was put as high as this in the closing moments of my learned friend submissions, advice which led to the principle of Rule 15 being disapplied. That, in our submission, is wholly wrong and misrepresents the position. First of all, Mr. Justice Tier, in a very careful and principled approach, applied a two-stage process. First, he asked himself whether, as a matter of law, the crossing rules applied. And if I can ask the court to turn up his judgment, because it's an important point insofar as the respondents seek to bolster their argument by relying upon answers given by the assessors to questions which had nothing to do with the issue with which your lordships are concerned, or which this court is concerned. If I can ask you to turn in the judgment of Mr. Justice Tier, please, to page 37 in the bundle, 199 in the bundle, paragraph 37. And what the judge says at paragraph 37 is the principal dispute in this case is whether Rule 15 applies. It is necessary to resolve this dispute before considering the respective alleged faults of the vessel. What he then does, in an analysis which we say is wrong, for the reasons of law we've already developed, is he analyses that question, the a priori question. He then reaches a conclusion about that at paragraph 71, page 207. That's in relation to the crossing rules not applying for the reason 2, and then paragraph 64, paragraph page 205, the rule 15 does not apply. What he then does, that's the first stage, without any reference to the assessors whatsoever, quite correctly. What he then does, having disapplied the crossing rule, he then has to ask himself, in a situation where the crossing rule does not apply, and therefore the only rule of seamanship, the only rule which binds the Alexandra 1 is General Rule 2, what, as a matter of General Rule 2, should the Alexandra 1 have done? Rule 15 not apply, as I've held it not to apply. And if you then go on, you see that when it's then in the context of the fault on the part of the Alexandra 1, that the passage that my learned friend cited, go to please page 213, the fault which was relied upon in a non-crossing situation was that the Alexandra 1 got too close to the end of the channel. And therefore the questions were put in the non-crossing rule context, Rule 2 only, at page 214, did good seamanship require Alexandra 1 to keep a certain minimum distance from the buoys? So that has no bearing whatsoever on whether the crossing rule applies. It's completely misleading to suggest that it does. What would have happened, and what would happen in this case if this court were to allow the appeal, would be the court would find that the crossing rules applied, and then the court would then ask the assessors, in compliance with the duties which the crossing rules impose upon the Alexandra 1 as the giveaway vessel, what should she have done and when? Because then she would be under a completely different obligation. She would be under the obligation under Rule 16 to take early, prompt and substantial action. And for my learned friend to submit, oh, well, it wouldn't make any difference because we've already been penalised for not doing what we did, what we didn't do at C-4, is completely to miss the point. Because the crossing situation would have been engaged much earlier, C-20, there might be an argument, C-21, C-23, it doesn't really matter, C-18. The crossing rule situation would have been engaged then, and that would mean that the Alexandra 1 should never have been in the position she was in having to make last-minute decisions at C-4. That's the whole point of the crossing rule situation and the obligation on the giveaway vessel, see Mr. Justice Sheen in the Maluja number 2. You get out of the way early so that the close quarter situation never arises.
Mr. Rainey, can we assume from the judge's question at paragraph 93 on page 214, did good seamanship require Alexandra 1 to keep a certain minimum distance, that he was inviting the assessors to assume that the crossing rule didn't apply? Because presumably he wouldn't have made his mind up by that stage, and the assessors wouldn't otherwise have known on what basis in relation to the crossing rule he was proceeding.
We would submit that the reason he's asking about good seamanship is he's asking in the Rule 2 context, because had he asked, had he considered a crossing rule context, he would have had to ask good seamanship in relation to her giveaway obligations. So this question is necessarily premised upon his view, which I don't have the precise chronological sequence in which the questions came out, but it must necessarily be premised upon his view the crossing rules didn't apply. And therefore you can't reverse engineer whether the crossing rules apply by fishing around in the views of the assessors on the factual scenario when the crossing rules don't apply. That was the impeccable approach of Mr. Justice Tier, wrong on law, but impeccable approach. The Court of Appeal, unfortunately, when dealing with the East-West situation, were much more muddled, with the greatest respect, and did not make it clear to the assessors whether they were considering it on the basis that the crossing rules did apply and didn't apply. But we've dealt with that in our case, and time doesn't allow me to go any further to it. But therefore, the views of the assessors below are of no assistance to this court in reaching a decision on the questions of law on issues 1 and issues 2. and the advice did not shape the view either of the judge or of the endorsement of that wrong view in law by the Court of Appeal. That's my first general point. My second general point is in relation to the pilotage boarding area point, which, as I've said before, was a point that came up only in the Court of Appeal's judgment and formed no part of Mr. Justice Tier's analysis of issue 1 below. I've already made the point there are no special rules in areas where vessels must navigate to take on pilots or pass through waters where pilot stations or boarding areas are situated. The crossing rules apply in full vigour for obvious reasons. If two vessels are proceeding in a pilotage area trying to pick up pilots, or one not to pick up pilot and one to pick up a pilot, and a crossing situation is created, why shouldn't the crossing rules apply? See the Albano, the Ada and the Sappho, and the Roanoke. Secondly, it makes absolutely no difference in that general principle that the pilot area here is at the channel mouth. The crossing rule is still dealt with in the same way. Vessels are still going to be going across west-east and east-west. The only question is, it doesn't matter whether they're going to pick up pilots or where in the pilotage boarding area they're going to pick up pilots. Assume one is going to pick it up because the pilot is in that particular situation. He's going to go right across the channel and pick it up on the east side of the pilotage boarding area. Or he's going to go right across and pick it up on the west side. We've got a crossing situation. Thirdly, and this was a point that came out of Ms. Ratnam's proposed question to the assessors, which in our view is entirely unnecessary and would be irrelevant to the issues this court has to determine. The point seems to be that, well, you can't have crossing rules because the obligation on the stand-on vessel, us, coming up the channel into the pilotage boarding area, would have us, I think she put it, steaming at 12.5 knots right into a crowded pilotage area. Well, that is wrong at a number of levels. First of all, if the pilotage area is empty, there's absolutely nothing wrong with us steaming at 12.5 knots into the pilotage boarding area. But secondly, and this is to forget the principle which the Court of Appeal misapplied and the judge didn't have in mind, the stand-on vessel obligation under Rule 17 is flexible. Take the example of the Roanoke. In the Roanoke, the vessel actually slowed down dramatically to pick up a pilot and was held still to be complying with her Rule 17 duty to stand on and maintain her course and speed. Why? Because it's not the course and speed which you're then doing and you must stick to forever and ever. It's the course and speed which you do given the piece of navigation you're engaged upon. Take the example, I don't have time to take you to it, but I would ask the court to read the decision in the Taunton, which I'm reliably informed, I still don't have a page number for it, where the Court of Appeal had to consider a vessel which was widely divergent in course. And Lord Justice Grutton said, it doesn't matter if a vessel slows down and stops, it doesn't matter if a vessel alters course to 16 points. In the particular course of navigation in question, the stand-on vessel rule is flexible. And so here what would be the position? Let us take a pilotage boarding area that is crowded, like a Singapore pilotage boarding area, and you come out of a channel into the boarding area. Your stand-on vessel must still comply with the other obligations under the collision regulations, a point made by my Lord Briggs. In particular, Rule 6 as to speed. So coming out of the channel, you have no right, as a vessel coming out of the channel, standing on and keeping your course and speed, to maintain it in breach of Rule 6. You slow down as appropriate, and any vessel observing you will know when you're standing onto her that you may have to slow down for other vessels in the pilotage boarding area. So with the greatest respect, the pilotage boarding area is a complete red herring, which was introduced by the Court of Appeal. And the oddity is, it appears to be said on this point that the crossing rule can never apply if the stand-on vessel has to go into a pilotage boarding area. Well, let's assume the stand-on vessel is approaching the pilotage boarding area, not from the narrow channel on the southwest side, but from the northeast or something like that. And let's assume she has to stand on into the pilotage boarding area. Is the same principle to apply? In our submission, that was an afterthought by the Court of Appeal, which is of no assistance to the resolution of the issues on this appeal. So those are my general points. If I now turn to issue 1, and there are two overarching questions which this court has to grapple with. The first is the underpinning, the main plank of the decision of the trial judge and the Court of Appeal, that there was an incompatibility and inconsistency between applying Rule 9A and particularly Rule 17A1 to the stand-on vessel at the same time. And what's happened is that there's been a failure of analysis. The issue this court is involved on is the construction of the rules. The issue this court is concerned with is the construction of the obligations imposed upon a vessel under the rules. What are you obliged to do? If you are coming up a channel to the mouth and you're in a crossing situation, and again, whether the crossing situation is in the channel or outside the channel, you are under two obligations. You keep right, keep the starboard side of the channel, and you maintain your course and speed. As a matter of obligations, there is no inconsistency whatsoever between those two obligations. What's happened is that the respondents have effectively dragged in by what happens when you're in breach of the obligations. But that's not what the collision regulations are seeking to deal with. The collision regulations are seeking to deal with sensible rights, sensible rules of the road. So you can have two obligations. We were under two obligations if the crossing rules applied in this case, just like the King Stephen was in the Ashton. We were required to keep to the starboard side of the channel. We were required to maintain our course and speed. You can be in breach of neither. You can be in breach of one or the other, or you can be in breach of both. In the Ashton, the King Stephen was in breach of both. But that doesn't help you understand whether the obligations as imposed by the rules are mutually incompatible, so that you have to discard one because you can't apply them both at the same time. And in our submission, there's a fundamental failure of analysis in relation to that. The Ashton, with all due respect to Mr. Morley, who we suspect him, does not rank of the same calibre as Captain Cockcroft, Captain Lemaire, and the editors of Marsden. The Ashton has been long cited as a good example of a case, the sort of example that Mr. Justice Wilmer had in mind in the Empire Brent, of a case that crosses, of a case of a vessel that crosses in a narrow channel. Now, in the Ashton, the King Stephen, her navigation was so bad that it didn't really matter which rules applied. She was going to get it in the neck anyway. But the judge found that she was in breach of Rule 9A and was in breach of Rule 17A1. But critically, showing that he had applied carefully the crossing rules in the channel, the other vessel, the Ashton, Alexandra I in our case, was found liable only because she was the giveaway vessel and was in breach of her giveaway obligation. So with all due respect to Mr. Morley, in his article, the fact that a highly experienced Admiralty judge, Sir Gorrell Barnes, one of the doyens of Admiralty judgeship, if I can put it in that way, in those days doing collision cases day in, day out, without reserving judgments, instinctively he knew, as Mr. Justice Wilmer in the Empire Brent has confirmed, that in a crossing situation in a narrow channel, you apply the rules. If you're applying them within the channel, why aren't you applying them outside the channel? And remember that in the Ashton, the trawler was crossing the channel preparatory to getting into the channel on the other side. And that's a preparation case, if ever there were one. That's my first overarching point. My second overarching point is what is the principle or the proposition that this court is being asked to uphold? What will be the ratio of this court's decision? What was the ratio of the decision? Apparently this court is being asked to endorse the ratios of Rationes Decidendi of Mr. Justice Tier as endorsed by the Court of Appeal. Well, let's take that in stages. Mr. Justice Tier acceded to a vicinity test and acceded in full, because he accepted her argument, although he didn't then go on to formulate what the proposition was. He accepted in full Mr. Elver-Atnam's argument as recited in the judgment. That is a vicinity argument and a preparation argument. The Court of Appeal, unfortunately, it's very difficult to discern what the ratio is, because they said, well, we're not saying very much beyond the facts of this case. But as they upheld the judge, they must be taken to endorse the same principle. So what principle is this court being asked to rule is the correct construction of Rules 15 and 9A and 2 on the facts of this case? It appears to be a vicinity test, and the questioning from the justices, the vicinity test has not been watered down or departed from. And it appears also to be a preparation to enter test. So we have a vessel which is not in a position to enter, which is not entering, which needs a pilot before she can enter, She can't enter until I come out because I've got to give her my pilot. And which is not lined up or shaping in any way to line up, but is going across the channel. And in those situations, in that factual situation of a vessel which, in my Lord Briggs's words, is effectively bumbling around outside waiting to go in, and bumbling around across and athwart the channel, transverse to the channel, the crossing rule is not to apply as a matter of legal principle. So what is the principle? In our submission, it's very, very difficult to analyse it. Is it that, well, the crossing rules don't apply at all in the vicinity of the mouth? Well, that can't be right, because to take the example that my Lady Arden was positing, what of a vessel that's not intending to go in and is going straight across the mouth, right in the vicinity of the mouth? Let's assume the Zacher Bravo had come further down. Is she a crossing vessel, or is she not a crossing vessel because she's in the vicinity of the narrow channel? Well, it's very difficult to know on the ratios below and the argument. And if it is a vicinity test, well, then my Lord Burroughs' question comes in, well, what's the vicinity? How close does it need to be? 5 cables, 2 cables, a nautical mile, 2 nautical miles? What are the crossing situations that are being created? That's the vicinity aspect. What of the preparation aspect? Well, the preparation doesn't tell you anything about how the vessel is being navigated. I can prepare for entering in the future by steaming right across the channel mouth. I'm preparing to enter in 10 minutes' time, but it would only take me 5 minutes to get across the mouth. I am crossing the mouth, dead athwart it, dead transverse to it. Why is the fact that I'm preparing to enter in 10 minutes disables Rule 15, when Rule 15 offers a perfectly clear and properly applicable basis of priority when I'm navigating as I am navigating? Take another example. I'm preparing to enter. I've left it slightly late to make my starboard turn. I therefore continue across the mouth of the channel, go round to port, come down with a view to dropping down the channel again, this time on the starboard side. I'm preparing to enter. That manoeuvre may only take me 5 or 7 minutes. But while I'm on my passage across the mouth of the channel, I'm crossing. It makes no difference that I'm preparing. And then we have other factors which are ingredients in this new statement of principle, which this court's being asked to endorse. We've got vicinity, and we've got preparation. We now have intention and knowledge of intention. Now, that is a complete distortion of the principles which have been long settled in the Pekin, the Alcoa Rambler, and the Roanoke. Intention, of course, can be assessed, but the way you assess it, the only reliable way you assess it, is to assess it by observation. You may know from a VHF message you've heard that the Alexandra 1 is intending shortly to enter the channel. You may know that she's intending shortly to board a pilot. You may think, well, then she'll probably go around to starboard pretty soon. And then she doesn't. And as you watch her, she tracks across the channel. How is your knowledge of her intention to board a pilot sometime and to enter the channel sometime of any assistance in understanding whether Rule 15 applies? It is absolutely anathema to the way in which collision matters are dealt with, and on the obligation on mariners to observe and to form a view, an objective view of intention from what the vessel's outward manifestations are. So in this case, this vessel was not shaping to enter on any view. She was not entering at all. She was merely preparing to enter. And no case suggests, I'll come to authority in a moment, but no case suggests that a preparation to enter is a reason for disapplying the crossing rules. Why should it? Because if you're planning to go across with an intention to enter by going round, or go across, pick up the pilot and then go around, then the crossing rules apply. The fact you're intending to go in, and the fact you're still preparing to go in, is neither here nor there. And that brings me then on, those are my 2 overarching points, but it's not really a let-out for the respondents to say, well, this court's really only dealing with the facts in this case and shouldn't go any further. this case will be a seminal case on the interaction of Rule 15 and Rule 9A. All the cases have been cited, and whether the extension principle or the continuity principle has a wider application than it has been traditionally always applied, the vessels actually entering or shaping to enter, is a major point of importance. These sorts of facts come up over and over again, and therefore they need to be addressed on a principled basis. The Court of Appeal, perhaps sensing the enormity of the decision it was making, then sort of tried to confine it to the facts, but one can't confine it to the facts before you've identified the principle. And then you just ask whether the facts are within the principle. You can't say, well, I'm not going to identify the principle, but it applies to these facts. So, my Lord Hampden.
Just sorry, on your approach of it being required to shape up, navigate by reference the channel, is there any vicinity element to that? I mean, how far out does it go?
Well, that's a very interesting question, my Lord. I mean, it's certainly in relation to the Yao Hai, the vessel was shaping up. I haven't got the plot in front of me, but for about 5 or 6 minutes, quite a long way out, and therefore the extension could have been run further out. I think the court in Coolumessin, both the first instance court and Lord Clark, were careful to confine their remarks to the entrance to the channel. And that may leave the vicinity of that slightly vague. But the real test is whether you're shaping, because you can be shaping, as your Lordship puts to me, from quite a long way out. And take the example of the Canberra Star. The City of Lions was shaping almost from the time she left the ammunition dock. And she got herself straight into the channel, onto the right side of the channel, put up to full speed, 15 degrees true, and then all that nice straight line straight down to the Lower Cliff Buoy. So there will be a vicinity element, but in our submission, the crucial element is are you a shaping vessel or not? If you're a shaping vessel or not, the other vessel knows what you're doing, and the position then is that both vessels are intending to pass port to port, and you don't need then the crossing rule. Why don't you need the crossing rule? For the same reason you don't need it in the channel, because the vessels are now effectively proceeding along the course of the channel, one within, one without. So those are my general submissions. In relation to authority, it leaves me to deal with, I think my propositions have been described as forensic, but they're not, my Lord, because there's a major difference in principle between a vessel which is entering, just take the example that my Lord Hampden was putting to me from the Coolumessin case, and shaping on a course to enter, and a vessel which is not shaping on a course to enter. And the distinction couldn't be more stark, because you'll have in mind what the judge said about it. My Lord Hampden took my learned friend to paragraph 70 in Mr. Justice Tier's judgment. So let me find the page number for that. Yes, it's page 70. As she
207.
Thank you. 207. Thank you very much indeed, my Lord. Vessel proceeding very slowly, progressing broadly east-southeast direction towards the entrance as she waited to embark a pilot. So she's not, as it were, entering, she's waiting to embark a pilot. But more importantly, one turns on to page 217, an important finding of fact. Which was that the Alexandra I decided to head across the approach to the channel rather than at C-5 or C-4 to turn to starboard, so as to pass the Eversmart port to port in the approaches. And then he describes that to the oral lookout, and therefore she was crossing across the channel and could no longer have reached the channel. So this is a case about as far away from the plot in the Coolumessin case or in the Canberra Star, if we had a plot, as it would be possible to get. And it's not a forensic distinction, that is the distinction. If you're going across and not entering, you're not entering. And you haven't lined up to enter, and you're not proceeding along the course of the channel to enter. The two are really as different as chalk and cheese. It's not a forensic distinction. And the extension principle cases only apply to vessels which are already entering. And the difficulty with intention and knowledge is, we'll take factually our case, If one vessel, as in our case, didn't have a very good lookout, then no one actually knew what the other vessel was doing. And so that doesn't really help you by saying, well, let's find out what they thought about it. But if you take two examples in our case, phases change. You could have a vessel which was shaping up on the course to come straight down, like the City of Lions. It was right over hard by CP1 buoy, but by the number 1 buoy, so she'd be on the starboard side. She then changes course to cross the channel for some reason. Engine problem, change of orders. Pilot said, I'm going to be late. The Rule 9A situation changes into a crossing situation. That's just entering into a new phase. The cases have always been able to handle that very easily. Take another situation where the vessel is crossing, but then decides to turn on her shaping course. Rule 15 applies before then, Rule 9A applies after it. So there will always be factual assessments to be made. That's what observation of vessel movement is concerned with. The court already has my submissions in relation to Cunamisson and the Canberra Star. These are entry cases, shaping cases, and therefore the statements of principle being made by Lord Clark were anchored in the facts he was considering. He was not considering a preparation case of a vessel slowly proceeding across or athwart the channel. The Ashton I've already addressed. It's a highly significant authority that's been cited in Marsden and Captain Cockcroft and Captain Lemeyre's book for a very long time as absolutely establishing the principle that crossing rules apply within the narrow channel. Mr. Morley's view in our submission is of very little weight and is wrong. In relation to Mr. Morley's article generally, the difficulty with Mr. Morley's article is he's identified a governing principle, which is the principle that Mr. Justice Tier rejected because he said that we were not responsible for the crossing situation and the risk of collision. I.e., had we gone over better to starboard, it wouldn't have made any difference. So the counterfactual plot, which was said to say, well, the collision would have been avoided had we done what we should have done, is no reason for disapplying Rule 15. Mr. Justice Tier specifically rejected that argument by Ms. Selver-Attman, and the Court of Appeal, when it was sought to be resurrected, regarded it as hopeless. So in our submission, the counterfactual does not assist. And that's all I wanted to say about issue 1. And now can I deal with issue 2, unless the Court has any questions for me on issue 1. Yes, my lady.
Just a quickie, your list of propositions doesn't actually take us to Alcoa. I just wondered whether
I apologise for that.
No, I just wondered whether it could properly be said that that gives the principle of interpretation, namely that you should interpret the rules so that the crossing rule has priority and applies unless it is obviously excluded by other rules.
My lady, that is a suggestion which I very much welcome. When I opened this appeal, that's what I said. And so there should be a proposition 0, if you like, which precedes proposition 1, which is the Alcoa Rambler principle, which we've stressed in our appellant's case, and which I stressed in opening, namely that the crossing rule should be given the widest possible application wherever you're in a crossing situation where the rules define, see the Alcoa Rambler. And as I think I said in opening, therefore you need a very good reason to disapply them to a crossing situation. But I'm grateful for that addition, or a suggested addition, and I would accept that that should be put in.
Thank you.
So issue 2, which is the course point, it's important to have in mind that this issue concerns a finding by the learned judge, endorsed by the Court of Appeal, that the Alexandra one was not on a sufficiently defined course. He did not find that we were not on any course at all. And the whole difficulty with this argument, it came up very late in the day before the trial judge, is that course can mean different things. You can have a very precise course, i.e. the course which is being steered by the vessel. I steer a course of 210. That is my course. You can have a course that is being described by a vessel in the sense of the general direction she's going. So a course which is east-southeast. You can have a course which is generally described, take the facts of the Taunton again, by a vessel which is crabbing very badly to port, coming round to starboard, very badly to port, coming round to starboard. She is on a course suitably identifiable to Cardiff Harbour. So the difficulty with this area is, first of all, in identifying what cases which use the word course when they're not considering the particular issues which you have to consider, what they actually meant by it, whether you're actually addressing their mind to the issue at all, and whether the implication of the course requirement into Rule 16 is justified either because of the language of Rule 15 or the language of Rule 16. We know there's a course referred to in Rule 17 because it's express, and that's been specifically considered in the Alcoa Rambler. And the course for those purposes has been defined by the Alcoa Rambler. But this case concerns the other way around. And in our submission, the court's got to be very, very careful about importing a course requirement which is not present on the face of the rules. The rules say the vessels have to cross. And to take my Lord Briggs's question to my learned friend, it is the facts of this case would be very, very stark. You have a vessel which is having main engine orders, dead slow ahead, which the only reason why she's doing this a little bit as she goes east-southeast is, as the judge said in his judgment, because she was manoeuvring very slowly, and she's not a very manoeuvrable ship. But she's still being navigated. In those circumstances, to say, well, let's assume that the crossing rule could potentially apply. When she speeds up a bit, she puts 3 knots on or 4 knots on, her head steadies. Now she's a crossing vessel. Before that, she wasn't, even though she was still coming down on east-southeasterly course. In our submission, it makes absolutely no sense. And we'd asked the court very carefully to go through the facts found by Mr. Justice Tier, because what he's dealing with is a sufficiently defined, fixed course.
Yeah.
He's not dealing with whether this vessel's on a course at all. Of course she's on a course. If you forgive the pleonasm. But sorry, my Lord Briggs.
I think, Mr. Rainey, you say, don't you, that a ship is on a course, not necessarily a sufficiently defined course, if it's moving over the ground. Because what it's doing through the water may be irrelevant to whether it's crossing. But if it's moving over the ground and its direction over the ground is going to intersect with another vessel which is also moving over the ground, then they're crossing.
My Lord, absolutely.
And they're only crossing, they're not necessarily at risk of collision unless the point of intersection between the two courses is the same.
Yes.
Or same or nearly the same.
Yes, because they don't need to be the same as the judge found, because if they bring you into a close quarters situation,
yeah, exactly.
Like Miss Selvaretton's point, well, you could have got past by some cables. Well, that doesn't matter because you're so close, you shouldn't be there anyway. That is entirely our submission, my Lord, and that is endorsed by the Broomfield, and with the greatest of respect to the courts below, it's endorsed by common sense.
Well, it's only if the ship in the position of the Alexandra is moving over the ground that she will stay on a steady bearing with the Eversmart unless she's already dead ahead of her, which she wasn't.
Absolutely, my Lord.
Yes.
Yes, absolutely. If she wasn't moving, then she wouldn't be creating the risk of collision, which is specifically identified in Rule 7, namely your bearing isn't changing.
Yeah.
It's not like the Devotion 2, where the bearing didn't change because the Devotion 2 was running down straight on top of a stationary vessel. But here you've got 2 moving vessels with the bearing not changing. And it is to be said, and they are crossing, and it is to be said that as a matter of principle, this court should say, in crossing situations like that, which are going to come up lots of times, very big, unwieldy ships going at slow speeds. Everybody knows where she's going. She's tracking across to Algeciras. She's going to whatever other harbour. And she's in a broad direction. But because she's slow and she's a bit unwieldy, or there's a tide or a current or windage, she's doing that a bit. Well, the crossing rules don't apply. And the extraordinary thing is, if the Alexandra one sped up and put herself onto 5 knots, everything would steady on. And then suddenly, bingo, the crossing rules apply. That can't be a sensible way of approaching it. It's not the way the courts approached it in the Broomfield. And we do know enough about the facts of the Broomfield. We had a trawler that was stopped. She shackled her rudder so she was starboard helm, so she didn't have effective steering anymore, and she just drifted to the southwest wind. Now, it's very, very difficult to think of a vessel like that drifting in a nice, sufficiently definite course. She will be drifting, but in a general track. That general track was such as to take her across the path of the Broomfield. And therefore the Lucania was obviously a giveaway vessel, and the rules applied. And so as a matter of construction, and again, this court is considering these matters as a matter of construction, where do you get the support for importing into Rule 15 and Rule 16 that the giveaway vessel must be on a sufficiently definite course? And the difficulty, my lord, is then you need to consider why the stand-on vessel has this duty. And this brings me to the authorities. In relation to the Savina and the Orduna and the Pekin, the issue which this court has to grapple with was not before the court. There's no question of what the obligation was of the giveaway vessel. So there's nothing binding in any of those. And the fact that there are general statements of principle about vessels being on courses could as well accommodate the discussion that I've been having with my Lord Briggs about what a course is in general terms as anything else. It takes two to cross. That means you've got to be on crossing courses lato sensu, not stricto sensu, and that's enough. And that's all in our submission that those general statements of principle were dealing with. Because they might have had in mind, well, if you're not moving at all, and you're not progressing, then you're not in a crossing situation. Whether that's right or not depends upon the devotion to and the passage in Cockcroft and Lamar. That's an issue this court doesn't need to consider stationary vessels, or they may need to have to say something about them. But we're in a case of two moving vessels, and that is enough. The avance, so that's group one of the cases which don't actually deal with the issue at all, and just have general statements of principle about courses. Group two there's only one case in group two, which is my learned friend's case, the avance. The facts of that case were pretty extraordinary. You have to bear in mind that the argument was that the avance was a stationary vessel, and therefore the crossing rules didn't apply. The avance was a stationary vessel. I asked the court to read the facts again. The avance had been stationary for quite some time. Indeed, she was having engine orders to back up astern to keep her in one fixed position, stationary, not to move. And therefore the other vessel, the putative stand-on vessel approaching her, would see a stationary vessel, and would see a stationary vessel all the time she proceeded. In the last 3 minutes, she kicks ahead. In our submission, Mr. Justice Brandon was dealing with those very particular facts. Insofar as he applied the Alcoa Rambler, the only sense that can be made of it is that he was saying, well, you can't blame the other vessel because this vessel had been stationary for so long, she had no idea that we were in a crossing situation. And that makes sense, simply as a matter of observation. But it doesn't lay down a legal requirement that you've got to be on a definite course of the giveaway vessel before the crossing rules are engaged. The devotion, then there's group three of the authorities, which is the devotion to and the Broomfield. The devotion to is valuable, whatever you think about the analysis of the stationary ship, because Lord Wiley considered particularly the wider sense of course in a dictionary definition. And he was satisfied that it was a prerequisite that the vessel had to move or to progress. Again, the answer I gave to my Lord Briggs is supported by the devotion to. All it requires are moving vessels relative to each other. And if the moving vessels are relative to each other and the bearing doesn't change, then you have a moving vessel crossing situation with the risk of collision as defined by the rules. And in our submission, there's no warrant for saying that falls outside the crossing rules. The Broomfield I've already addressed. But can I ask the court to note that Captain Cockcroft and Captain Lemaire's book cites the Broomfield for particularly the same proposition we cite it for. Namely, when you're stopped or just drifting, you will still come under the crossing rules. And put it this way, my lord, you don't have the right not to anchor and to just drift around in the water, describing some sort of loose course, and to say, you keep out of my way. It's entirely Lord Justice Farwell's point in the Roanoke. If we then come to the textbooks, last of all, Marsden does not cite the avance for the giveaway vessel principle. Marsden cites the avance in the context of the obligation on the stand-on vessel to be on a definite course. And that's because the stand-on vessel has to be, because the giveaway vessel needs to know what she's doing. This is the mistake made by the Court of Appeal. The Court of Appeal seems to think, well, the stand-on vessel needs to know what the giveaway vessel is doing. Well, the stand-on vessel knows what the giveaway vessel is doing. By what she's doing, she's going to cross. And as the bearing isn't changing, she's going to cross the risk of collision. Therefore, all the stand-on vessel wants is the giveaway vessel complies with her obligations and gets out of the way. And to try to say that the stand-on vessel can't comply with her last, as it were, the last-ditch minutes before the collision obligations under 7A2 and 7B, 17A2 and 17B, is nonsensical, because by that stage, the vessels are close. The stand-on vessel's waited as long as it can to see whether the giveaway vessel's getting out of the way. The giveaway vessel isn't getting out of the way, and therefore the stand-on vessel has to take emergency action. Captain Cockcroft and Captain de Meer's book, I've already dealt with. Mr. Morley's article is wrong because he fails to grapple with the fact the Court of Appeal and Mr. Justice Tier did not hold us responsible for creating the risk of collision. And with all due respect to Mr. Hurst's book, it is not at all in the same calibre as Captain Cockcroft and Captain de Meer's book and the long editions of Marsden. So for those reasons, unless I can help the court further, we submit the appeal should be allowed on both issues 1 and 2. And this court should take the opportunity of endorsing the principles in the Alcoa Lambda and making it absolutely plain that in a position where the trial judge found this was a crossing situation with a risk of collision which then eventuated, the crossing rules should apply, unless there's a very, very good reason. The only good reason would be if you're entering the channel as the vessel's coming out, or you're shaping to enter the channel. That is not the facts of this case. Those are my submissions, my lady.
My Lord Hamblin asked your learned colleague whether there would be any question to be put to the assessors. Now, you may not want to answer that. She just gave us one example and would need to think about it. But what do you have to say, if anything, on that?
We have no questions to the assessors.
Thank you. Thank you.
Yeah, but yes, my learned junior, my learned colleague, Mr. Jacobs QC, reminds me that, of course, if the court were to find that the crossing rules did apply, then we would be into apportionment. And then if this court were doing the apportionment, there would be lots of questions to the assessors. But in relation to the issues which this court is grappling, no.
Thank you.
Are there any further questions from Mr. Rainey? Well, thank you, Mr. Rainey. We're very grateful. Will not surprise you to learn that we're going to take time to consider our judgments. We thank you very warmly for your submissions and Ms. Salvaret. And we also thank all those who metaphorically are sitting behind you, who've made the preparations for this hearing, which has been very efficiently dealt with. We're also very grateful to Captain Nigel Palmer and Commander Nigel Hare, our assessors, who've been listening patiently throughout the proceedings. We will consider whether, in due course, we wish to take expert advice of the assessors on any questions of navigation and seamanship. If we do, we will afford counsel an opportunity to make submissions in relation to the question asked. We're very grateful to you all. Thank you very much. That concludes the hearing.